I was halfway through my morning coffee when I spotted the construction crew cutting down trees on my land, their chainsaws ripping through 100-year-old oaks like they owned the place. My name is Marcus Reynolds, and I'd bought this 40-acre property in rural Georgia, just outside Dalonga, specifically for the privacy. The house sat on a hill overlooking a valley of dense woods that I'd spent the last 3 years maintaining and protecting. I worked remotely as a software consultant, and this place was my sanctuary from the chaos of modern life. The property had clear boundary markers, a surveyed fence line, and absolutely no connection to the Pinecrest Heights HOA that governed the suburban development half a mile down the road. I grabbed my phone and practically ran down the trail toward the noise. What I found made my blood boil. A full construction crew, complete with a bobcat, was carving a 6-foot-wide path straight through my woods. They'd already cleared about 200 feet, leaving stumps and torn earth in their wake. "Hey," I shouted over the chainsaw noise. "What the hell do you think you're doing?" A guy in a hard hat turned off his saw and looked at me like I was interrupting his lunch break. "HOA trail project. Got our permits and everything. This is private property, my property. You need to stop right now." He pulled out a crumpled map from his back pocket. "Says here this is common area for the Pinecrest development." I snatched the map from his hands. Someone had drawn boundaries that extended well beyond the actual HOA property lines, essentially claiming a quarter of my land as their own. "This map is wrong, completely wrong. My property line is marked with orange survey tape on those posts. See them? You're about 300 feet onto my land." The foreman wandered over, a stocky guy with a clipboard. "Look, buddy, we got authorization from the HOA board. You got a problem, take it up with them. We're just doing our job. Your job is trespassing and destruction of private property." "I'm telling you right now to stop," he shrugged. "Can't stop mid-project, got a schedule to keep." I pulled out my phone and started recording. "Then you're doing it on camera. I'm documenting every second of this." The foreman's face reddened. "You can't film us without permission." "On my own property. Watch me. And if you cut down one more tree, I'm calling the sheriff." I didn't wait for a response. I marched back to my house, pulled up the survey documents I'd received when I bought the property, and called the Lumpkin County Sheriff's Office. The dispatcher was polite but told me it sounded like a civil matter. I'd need to contact a lawyer unless there was an immediate threat. Next call was to my real estate attorney, David Chen, who'd handled my property purchase. He listened to my explanation and let out a low whistle. "They can't just claim your land for an HOA trail," he said. "But stopping them today might be tricky. I'll draft a cease and desist immediately and file for an emergency injunction. In the meantime, put up clear no trespassing signs every 20 feet along that trail they're cutting. Take photos of everything. Document all the damage. They're out there right now destroying trees that are older than both of us combined." "I understand, Marcus. Get those signs up. I'll have the cease and desist delivered today. We'll get this stopped, but we need to do it right." I drove into town and bought 24 heavy-duty no trespassing signs, then spent the next 2 hours posting them along the unauthorized trail and my entire property line facing the HOA development. Each sign was clear. Private property. No trespassing. Violators will be prosecuted. By the time I finished, the construction crew had packed up for the day. They'd carved out nearly 400 feet of trail, destroyed probably 20 mature trees, and left a scar across my property that made me sick to look at. That evening, I got my first visit from the HOA representative. A silver SUV pulled into my driveway, and out stepped a woman who looked like she'd been born clutching a rulebook. She was maybe 50, with that severe haircut that seemed to be standard issue for HOA board members, wearing a pantsuit despite the Georgia heat. Mr. Reynolds. I'm Patricia Hendricks, president of the Pinecrest Heights HOA. You mean the people who just spent the day destroying my property without permission? She smiled, but it didn't reach her eyes. I think there's been a misunderstanding. The trail we're developing runs through designated common area. Your common area ends 300 feet that way. I pointed toward the actual boundary. Everything here is my private property. I have the survey to prove it. Patricia pulled out a folder. According to our site plans from 2019, this area was designated for community use when the development was originally planned. I don't care what your plans say. I own this land. I have a deed. I have a survey. You have no legal right to be here. The previous owner had agreed to allow trail access. That was news to me. Then why isn't it in the deed? Why isn't there an easement recorded? I'll tell you why, because it never happened. And even if they discussed it, which I doubt, it was never formalized. I bought this property free and clear. Patricia's smile vanished. Mr. Reynolds, Pinecrest Heights is a community. We value cooperation and being good neighbors. This trail will provide valuable recreation space for families. Build it on your own property. The topography doesn't work. This route provides the best access to the nature preserve beyond your land. Not my problem. You're trespassing, you've damaged my property, and my attorney is filing an injunction tomorrow morning. Her expression hardened. I'd reconsider that approach. The HOA has significant legal resources, and we don't take kindly to residents who refuse to work with the community. I'm not a resident of your community. I'm not part of your HOA. My property predates your development by 20 years. You have no authority here. We'll see about that. Patricia turned on her heel and got back in her SUV, spraying gravel as she drove off. The cease and desist was delivered the next morning. By afternoon, I received a response from the HOA's attorney, claiming that my property was subject to a verbal easement agreement and that I was interfering with community improvements. It was complete nonsense, but it meant this was going to be a fight. David filed the emergency injunction request, and we got a hearing scheduled for the following week. In the meantime, the construction crew showed up again the next morning. I walked down to meet them, pointing at the signs. Did you not see these? No trespassing means no trespassing. The foreman handed me a paper. HOA says we continue working. They'll handle any legal issues. You're making yourselves party to a lawsuit. I have an injunction hearing scheduled. If you continue, you're liable for damages. One of the younger workers looked nervous, but the foreman just shook his head. Got a job to do. I called the sheriff's office again. This time, I got through to a deputy who agreed to come out. Deputy Morrison arrived about 30 minutes later, a tall black man in his 40s who actually took the time to look at my survey documents. This does appear to be your property, Mr. Reynolds, he said, after comparing my survey to the HOA map the foreman showed him. So can you make them leave? I asked. It's still a civil dispute. You've got a court hearing next week, right? Best thing is to let the judge sort it out. While they destroy more of my land, Morrison looked uncomfortable. I can ask them to pause work until the hearing. But I can't arrest anyone for trespassing when there's a legitimate dispute about property lines. There's no legitimate dispute. I have a legal survey. They have a hand-drawn map. That's completely wrong. The deputy pulled the foreman aside and had a quiet conversation. The foreman made a phone call, presumably to Patricia, and after some heated discussion, agreed to pause work until after the court hearing. It was a small victory, but at least they'd stopped cutting. The hearing couldn't come fast enough. I spent the week documenting every inch of damage. getting estimates for restoration from 3 different land management companies, and preparing my case with David. The courthouse in Dalonga was a historic building that usually handled property disputes and local ordinances. Judge Sarah Martinez presided, a no-nonsense woman in her 60s who'd been on the bench for 20 years. Patricia showed up with her attorney, a slick guy named Ronald Whitmore, who wore a suit that probably cost more than my truck. They'd also brought an engineer who testified that the trail was essential for community access and that the property lines were ambiguous. David systematically destroyed their arguments. He presented my deed, my survey from a licensed surveyor, the county tax maps, and even pulled up the original plat maps from when my property was first subdivided in 1983. There was no ambiguity. My property was my property, and the HOA had zero claim to it. The engineer's testimony fell apart when David asked him if he'd actually walked the property lines or just relied on the HOA's map. He admitted he'd never visited the site. Judge Martinez took about 5 minutes to make her decision. I'm granting the injunction. The HOA is prohibited from continuing any construction on Mr. Reynolds' property. Furthermore, I'm ordering the HOA to restore the damaged area to its original condition within 60 days. Patricia's face went red. Your Honor, that's unreasonable. The cost is irrelevant, Miss Hendricks. Your organization trespassed and caused damage to private property. You're responsible for fixing it. Mr. Reynolds, you're free to pursue additional damages in a civil suit if you choose. I left the courthouse feeling vindicated, but I knew Patricia wasn't the type to accept defeat gracefully. Sure enough, 2 days later, I found survey stakes all over my property with tiny HOA flags attached to them. Someone had come onto my land in the middle of the night and marked it up like they were planning another project. I pulled every stake and delivered them to Patricia's house, which was in the heart of the Pinecrest development. I dumped them on her lawn and took a photo for my records. She came storming out. You can't just dump trash on my property. These are your survey stakes from my property. Where they don't belong, I'm returning them. We have every right to survey common areas. For the last time, it's not common area. The judge made that crystal clear. Stay off my land. A neighbor was watching from across the street, filming on her phone. Patricia noticed and forced her expression into something approximating civility. Mr. Reynolds, perhaps we got off on the wrong foot. Why don't you come to our next HOA meeting? We can discuss this like reasonable adults. There's nothing to discuss. Your organization damaged my property and now you need to fix it. That's what the judge ordered. The restoration cost is significant. If you'd be willing to grant us an easement for the trail, we could use those funds to no. You haven't even heard the full proposal. I don't need to. The answer is no. The trail was built without permission on my private land. You're restoring it. End of discussion. I drove home, but the encounter left me uneasy. Patricia was planning something. People like her didn't just give up. The next week, I received a citation from Lumpkin County Code Enforcement. Apparently, someone had filed a complaint about excessive signage on my property. The no trespassing signs I'd posted were supposedly in violation of county ordinances about sign density. I called the code enforcement office and spoke to an inspector named Greg who sounded embarrassed. Look, Mr. Reynolds, I have to follow up on complaints. But between you and me, you're allowed to post no trespassing signs on private property. Whoever filed this complaint doesn't understand the code. Let me guess, Patricia Hendricks from the HOA. I can't confirm who filed it, but let's just say I've dealt with this particular HOA before. They're aggressive. So I'm clear, you're clear. I'll mark the complaint as unfounded. 2 days after that, I got a notice from my homeowner's insurance. Someone had filed a claim saying I'd caused property damage during a dispute with the HOA. It was completely fabricated, but it meant I had to spend hours on the phone with my insurance company explaining the situation and providing documentation. Then came the environmental complaint. Someone reported to the Georgia Environmental Protection Division that I was illegally clearing land and disrupting wetlands. An inspector had to come out, which cost me a day of work, only to find that I hadn't cleared anything the HOA had. Patricia was waging a war of attrition, trying to bury me in bureaucratic complaints and legal hassles. David advised me to document everything and consider filing harassment charges, but I wanted to see if the HOA would actually comply with the judge's restoration order first. The 60-day deadline came and went. Nothing happened. The torn-up trail through my woods remained exactly as the construction crew had left it. I filed a motion for contempt. That got their attention. Ronald Whitmore called David directly. My clients are prepared to fulfill the restoration requirement, but they need additional time. The cost estimates have been higher than anticipated. They had 60 days, David replied. The judge's order was clear. We're requesting a 30-day extension and proposing a payment plan for the restoration work. My client isn't interested in payment plans. Your organization has the funds. Use them. The contempt hearing was scheduled, and this time Patricia showed up looking less confident. The HOA had gotten multiple restoration estimates ranging from $40,000 to $60,000. They were arguing they couldn't afford it. Judge Martinez was unsympathetic. Miss Hendricks, your HOA approved and funded an unauthorized construction project on someone else's land. The financial consequences are your responsibility. I'm ordering immediate compliance. If the restoration isn't completed within 30 days, I'll hold you personally in contempt and impose daily fines of $1,000 until it's done. That got results. Within a week, a professional land restoration company was on my property, carefully removing the damaged trail, grinding stumps, and preparing the area for replanting. They worked with a forestry consultant I'd hired to ensure the restoration was done properly, with native species and proper grading. I thought that would be the end of it. I was wrong. The restoration was about halfway complete when I woke up one morning to find the entire trail area spray painted with orange X marks. Someone had marked every tree along the former trail path, as if they were designated for removal. But worse than that, someone had also vandalized my house. Eggs splattered across the siding, toilet paper in the trees, and the words "community enemy" spray painted across my garage door. That crossed a line. I called the sheriff's office and filed a formal report. Deputy Morrison came out and took photos, collected evidence, and actually seemed angry on my behalf. "This is criminal mischief," he said. "Possibly harassment. You got security cameras." "I do now." I'd installed them the week before after the survey stake incident, but they didn't catch this. Whoever did it knew where the cameras were pointed and stayed out of view. That suggests someone who's been here before, scoped out your property. The HOA has been on my land multiple times. Morrison nodded. I'll follow up with them. This kind of vandalism, especially targeting someone involved in a legal dispute, that's serious. The investigation didn't go anywhere immediately, but it put the HOA on notice. David also sent a strongly worded letter threatening to expand our lawsuit to include harassment and intentional infliction of emotional distress. The restoration work continued, though the crew was now nervous about being on my property. I didn't blame them. The situation had escalated beyond a simple property dispute. Then, I got the letter from the county. The HOA had filed a formal petition to have a portion of my land declared a public easement for trail access, claiming it was necessary for community welfare, and citing some obscure Georgia statute about landlocked parcels. It was absurd. The HOA's property wasn't landlocked. They had plenty of access. This was purely punitive. David and I filed a response, and another hearing was scheduled. I was spending more time in court than I ever had in my life, and it was draining. My work was suffering, my stress levels were through the roof, and I was starting to understand why some people just gave up and let the HOA win. But I was stubborn. This was my land, my home, and I wasn't backing down. The hearing for the easement petition was more elaborate than the previous ones. The HOA brought residents to testify about how much they wanted trail access, including a woman with 2 young kids who talked about the importance of nature education. It was pure theater, designed to make me look like the villain standing in the way of children experiencing the outdoors. David countered by pointing out that there were multiple state parks within 20 minutes, that the HOA development had its own common areas that could be developed for trails, and that you can't just take someone's private property because you want it for recreation. Judge Martinez seemed annoyed by the whole proceeding. Miss Hendricks, this statute you're citing is for situations where property owners have no access to public roads. That's not the case here. Your petition is denied. Patricia stood up. Your Honor, with all due respect, sit down, Miss Hendricks. I've heard enough. This court has already ruled on this matter. The HOA has no claim to Mr. Reynolds' property. Continuing to file frivolous petitions borders on abuse of process. If you bring this issue before me again without substantial new evidence, I'll sanction your attorney. Ronald Whitmore looked like he wanted to disappear into his chair. As we left the courthouse, David pulled me aside. They're not going to stop. Patricia seems personally invested in this fight. So what do? We go on a fence. File a comprehensive lawsuit for all damages, harassment, legal fees, and seek an injunction preventing them from filing any further actions related to your property. Make it expensive enough that the HOA board starts asking Patricia why she's costing them so much money. It was good advice. We filed the lawsuit the following week, asking for $200,000 in damages and fees. That's when things got really interesting. I received a call from a woman named Sandra Baker who lived in the Pinecrest development. She'd seen the news coverage of the lawsuit and wanted to talk. We met at a coffee shop in Dalonga. Sandra was in her early 40s, professional-looking, clearly nervous. I'm on the HOA board, she started. Or I was. I resigned last week because of how Patricia has been handling your situation. I'm listening. Patricia has a history of this kind of thing. She goes after anyone she perceives as a threat to her authority. There was a family 3 years ago who wanted to paint their house a shade of blue that wasn't on the approved color list. Patricia made their lives hell until they sold and moved away. That's insane. It gets worse. The trail project through your property wasn't actually approved by the full board. Patricia pushed it through using an emergency authorization clause that's supposed to be for things like storm damage repair. By the time the rest of us found out, construction had already started. You have documentation of that. Sandra slid a folder across the table. Meeting minutes, emails, financial records. Patricia has been using HOA funds however she wants. The trail project alone has cost almost $90,000 once you include the legal fees and now the restoration costs. That's not sustainable for an HOA our size. Why are you showing me this? Because it's wrong. And because I think if you have this information, your lawsuit might finally force the board to remove Patricia and get our HOA back under control. I thanked Sandra and immediately sent copies of everything to David. He was thrilled. "This changes everything," he said over the phone. If Patricia acted without proper board authorization, she could be personally liable for the damages, not just the HOA. And there might be criminal fraud issues if she misused HOA funds. We amended our lawsuit to include the new information and added Patricia as a defendant in her individual capacity. The response was swift and dramatic. Within a week, I received a hand-delivered letter from the Pinecrest HOA board informing me that Patricia Hendricks had been removed as president, and that the board was seeking to settle our dispute. The new board president, a retired accountant named Tom Morrison, called me directly. "Mr. Reynolds, I want to apologize on behalf of the HOA for everything that's happened. What was done to your property was wrong, and how it was handled was worse. We'd like to make this right. I'm listening. We'll complete the restoration to your satisfaction. We'll pay your legal fees and documented damages, and we'll put in writing that the HOA will never claim any interest in your property. In exchange, we're asking that you drop the lawsuit against the HOA itself. We're pursuing our own legal action against Patricia personally." I discussed it with David, who thought it was a reasonable offer. "You've made your point, and honestly, getting the money from the HOA is easier than trying to collect from Patricia individually." The settlement was finalized within a month. The restoration was completed beautifully. You could barely tell there had ever been a trail there. The HOA paid me $75,000 for damages and legal fees. And I got a permanent legal agreement that protected my property from any future HOA claims. But Patricia wasn't done. Even after being removed from the board, she couldn't let it go. I started getting anonymous letters in my mailbox. Nasty, threatening things about how I destroyed the community and made enemies I'd regret. My tires were slashed twice. Someone cut down a young oak I'd planted near my driveway. Deputy Morrison suggested I file for a restraining order, but I needed proof it was Patricia. The anonymous letters weren't enough. Then she made a mistake. I got a call one evening from a number I didn't recognize. I answered, and it was Patricia, clearly drunk, ranting about how I'd ruined her life and destroyed everything she'd built at Pinecrest. I recorded the whole thing on a second phone. She threatened to make sure I regretted moving to Dalonga, said she'd find ways to make my life miserable, and made some vague references to accidents that happen to people who don't respect the community. That recording was enough. David helped me file for a restraining order, and given the pattern of harassment and the threatening phone call, the judge granted it. Patricia violated the restraining order 3 days later by showing up at my property to deliver important documents. She claimed she didn't realize she wasn't allowed to contact me, but the sheriff's deputy who responded wasn't buying it. She was arrested for violating the restraining order and held overnight. The judge at her arraignment was not sympathetic, especially after the prosecutor outlined the entire history of harassment. Patricia was sentenced to 30 days in jail, suspended pending completion of anger management counseling and probation. She was also ordered to pay restitution for the property damage that could be linked to her, including my garage door and the slashed tires. But the real consequences came from the civil side. The HOA filed a lawsuit against Patricia for breach of fiduciary duty and fraud, seeking to recover all the money the organization had lost due to her unauthorized actions. That lawsuit was still pending, but her assets were frozen pending resolution. I also learned from Sandra that Patricia's husband had filed for divorce. Apparently, he was tired of being married to someone whose obsession with HOA authority had cost them their savings and reputation. 6 months after the whole ordeal began, I was finally able to enjoy my property in peace. The woods had recovered remarkably well from the restoration work. The new trees were taking root, and wildlife had returned to the area. I expanded my security system and kept the no trespassing signs up, but I didn't need them. The new HOA board was respectful and professional. They even invited me to their annual community picnic, which I politely declined, but I appreciated the gesture. One morning in early spring, I was hiking through my woods when I found Sandra walking near the property line on the HOA side. She waved and came over to chat. "How are things in Pinecrest these days?" I asked. "Much better. We've got a functional board now, people who actually care about running an HOA properly instead of using it for power trips. We're even working on developing a real trail system on our actual property." "Good for you." I wanted to say thank you. What you did, standing up to Patricia, it freed a lot of us from her tyranny. People were afraid to even paint their mailboxes without her approval. Now we've got reasonable rules and reasonable people enforcing them. I just protected my property. You did more than that. You showed that bullies can be stopped, even when they hide behind positions of authority. Sandra headed back toward the development, and I continued my hike. The woods were quiet except for birds and the rustle of wind through the trees. This was why I'd bought the property, for the peace, the privacy, the connection to nature. Later that week, I received a final piece of mail related to the whole situation. It was a check from Patricia's insurance company for additional damages they'd agreed to cover. The amount wasn't huge, but it represented closure. I deposited the check and used the money to fund a conservation easement on my property. Working with a land trust, I permanently protected the woods from development. No one could ever build on it, clear it, or run unauthorized trails through it. The land would remain wild forever. When the paperwork was finalized, I felt a weight lift that I hadn't fully realized I'd been carrying. The fight with the HOA had been exhausting and stressful, but it had also clarified what mattered to me. This land, this place, was worth defending. I settled into a new routine. My work picked back up, and I took on some interesting projects that kept me engaged. I started volunteering with a local land conservation group, using my experience to help other property owners protect their land from encroachment and overreach. One afternoon, I was giving a presentation to the conservation group about property rights and dealing with HOAs when a young couple approached me afterward. They just bought property near a development and were worried about potential boundary issues. "The HOA keeps asking for access to run utility lines through our land," the husband explained. "They're being pushy about it." "Get everything in writing," I advised. "Don't agree to anything verbally. Make sure you understand exactly what they want and what the long-term implications are. And get a lawyer involved before you sign anything." The wife looked relieved. We were feeling pressured to just be good neighbors and go along with it. Being a good neighbor doesn't mean letting people take advantage of you. Protect your property rights. Once you give them up, they're almost impossible to get back. They thanked me and left, and I realized that something positive had come from my ordeal with Patricia and the HOA. I could help others avoid the same mistakes and stand up for their rights. A year after the trail incident, I was working in my home office when I saw a car pull into my driveway. I tensed for a moment, old habits from the conflict, but relaxed when I recognized Tom Morrison, the HOA president who'd helped negotiate the settlement. I met him outside. "Tom, what brings you out here?" "I wanted to update you on something. Patricia's lawsuit with the HOA was settled last month. She had to sell her house to cover the damages. She's moved out of state. Good riddance." I also wanted to let you know that we've implemented new policies to prevent anything like this from happening again. All expenditures over $5,000 require full board approval and member notification. We've brought in an independent management company to provide oversight. And we've established clear protocols for property boundary issues. Sounds like you've made real improvements. We learned an expensive lesson, but I think the HOA is better for it. We're actually serving the community now instead of one person's ego. Tom handed me an envelope. This is an official apology from the board, along with a guarantee of non-interference with your property. I know we settled legally, but we wanted you to have something formal acknowledging what happened and our commitment to being better neighbors. I read through the letter. It was surprisingly heartfelt and specific, acknowledging the damage done and the stress caused. It wasn't just legal boilerplate. Thank you, Tom. I appreciate this. We appreciate you not destroying us in court, even though you could have. You were tough but fair. After Tom left, I sat on my porch and looked out over my land. The valley was green and lush, the trees creating a canopy that swayed in the breeze. Somewhere in those woods, deer were probably bedding down for the evening. A hawk circled overhead, riding the thermals. This was my place. I'd fought for it, protected it, and ensured it would remain wild and free. The no trespassing sign still stood along the boundary, weathered but sturdy, a reminder of the battle and a deterrent to future encroachment. My phone buzzed with an email from a new client. I skimmed it and smiled. It was a challenging project, exactly the kind of work I enjoyed. Life was getting back to normal, or rather, finding a new normal that was even better than before. I thought about Patricia sometimes, wondering if she'd learned anything from the experience. Probably not. People like her rarely did. But she was someone else's problem now, and I had my peace. As the sun set over the Georgia hills, painting the sky in shades of orange and purple, I raised my coffee mug in a silent toast to standing your ground, fighting for what's right, and never letting anyone tell you what you can and can't do with your own land. The HOA had tried to cut a walking trail through my private woods. My no trespassing signs had been just the start of a long battle. But in the end, the woods remained mine, wild and protected, exactly as they should be. I'd won not just a legal victory, but something more important. I'd established that property rights matter, that communities need to respect boundaries, and that one person standing firm can make a difference. The woods whispered in the evening breeze, and I listened, content in the knowledge that they would whisper like that long after I was gone, protected by the conservation easement, and the lessons learned from one stubborn man who refused to let an HOA bully him off his own land. 3 years later, I received an unexpected visitor. An investigative journalist from Atlanta named Michael was researching HOA overreach in Georgia and had heard about my case. "Your situation is part of a bigger pattern," he explained over coffee at my kitchen table. HOAs across the state are becoming increasingly aggressive, especially in areas where suburbs are expanding into rural land. What happened to you has happened to dozens of others, but most of them settled quietly or gave up. Why didn't they fight? Legal costs, mostly. You were fortunate to have resources and a good attorney. A lot of people can't afford that kind of fight. Michael asked if he could interview me for his article. I agreed, thinking it might help others in similar situations. The resulting piece ran in a major newspaper and went viral online. I received hundreds of emails from people sharing their own HOA horror stories. One email stood out. It was from a man in Florida whose HOA had annexed his property without his knowledge through some legal loophole. He was fighting it but losing hope. I connected him with David, who had experience with Georgia cases but knew attorneys in Florida who could help. That connection started a network. Property owners dealing with HOA overreach began sharing information, legal strategies, and support. David and several other attorneys formed a loose coalition offering pro bono consultations for certain cases. I became an unofficial advisor to the group, sharing my experience and encouraging people to stand firm. It was satisfying work, turning my negative experience into something that helped others. Meanwhile, my property continued to thrive. The conservation easement meant I got regular visits from land trust staff who monitored the property to ensure compliance. They were always impressed by how well the woods had recovered from the trail damage. "You'd never know there had been construction here," one monitor said during an inspection. "The restoration work was exceptional. It should never have been necessary," I replied. But at least it was done right. The land trust asked if I'd be willing to allow occasional educational hikes on my property. Carefully managed groups, nature education focused, no trails cut. I considered it for a while before agreeing with strict conditions. No more than 12 people per group, scheduled in advance, accompanied by land trust staff only. The first group was a class of 5th graders from Dalonga Elementary. Their teacher was passionate about environmental education, and the kids were genuinely excited to explore the woods. I tagged along on the hike, watching them discover salamanders under logs and identify different tree species. One kid, a small boy with glasses, asked me, "Is it true you fought the HOA to save these woods?" I fought them to protect my property rights. Saving the woods was part of that. "My dad says HOAs are evil," I laughed. "They're not all bad. They serve a purpose in some communities, but they need to stay within their boundaries and respect people's rights." The teacher thanked me afterward. "This land is special. I'm glad you protected it." "Me too." As the years passed, the whole ordeal with Patricia and the HOA faded into local legend. New residents in Pinecrest had no idea what had happened, and the current HOA board was professional and respectful. The development and my property coexisted peacefully. I renovated my house, adding a larger deck that overlooked the valley. I hosted friends for barbecues and quiet evenings watching the sunset. The security cameras remained, but they mostly just captured wildlife footage that I enjoyed reviewing. One camera caught a black bear wandering through in the spring, probably following the creek. Another recorded a bobcat slinking past at dawn. The woods were alive and healthy, a testament to what happens when you protect natural spaces. I also started mentoring young professionals in my field, offering remote internships that let them work from anywhere. Several of them visited my property, and I watched their faces light up when they saw the woods and understood why I'd fought so hard to protect this place. "You really can have it all," one intern said. "Successful career, beautiful property, peace and quiet." "You can," I agreed, "but you have to be willing to defend it when necessary." 5 years after the trail incident, I received an invitation to speak at a state legislative hearing on HOA reform. Lawmakers were considering new regulations to prevent the kind of overreach I'd experienced. I testified about my case, providing documentation and explaining how easily Patricia had been able to abuse her authority. I advocated for stronger oversight, clearer property rights protections, and consequences for HOA board members who acted outside their authority. The bill that eventually passed wasn't perfect, but it included provisions requiring HOAs to verify property ownership before taking any action that might affect private land. It also created a state-level complaint process for property owners dealing with HOA disputes. It was a small victory, but meaningful. Maybe it would prevent the next Patricia from destroying someone's property and peace of mind. I drove home from the Capitol building feeling satisfied. The fight had been worth it, not just for me, but for everyone who would benefit from the stronger protections. Back at my property, I took a long walk through the woods. The trail the HOA had illegally cut was completely gone now, reclaimed by nature. Young trees grew where stumps had been. Wildflowers carpeted the forest floor. A deer watched me from a distance, ears alert but unafraid. This was home. This was worth protecting, and I'd do it all again if necessary. But as I stood there in the dappled sunlight filtering through the canopy, I hoped it would never be necessary again. The woods deserved peace, and so did I. The no trespassing signs still stood along the boundary, faded now but readable. They weren't just warnings anymore. They were reminders of a battle fought and won, of rights defended and land protected. I walked back to my house as the afternoon light turned golden, content in the knowledge that sometimes standing your ground and refusing to back down is the only option. The HOA had learned that lesson the hard way, and I'd learned that I was stronger than I'd realized. My land, my rules, my peace. That's all I'd ever wanted, and in the end, that's exactly what I got.